Welcome everybody here to the bi-weekly webinar. This is something that Jim and I host. We love doing it. We love talking to agents. A little bit about myself. I'm a real estate agent myself, been doing this over 20 years, in there with the trenches with all of you. Also, I started an awesome online marketplace and social media platform for real estate called RealTrade. We launched about 2 years ago. We're actually ready now to pass 2,000 agents on the platform. We have thousands of buyers or sellers. The cool thing about RealTrade is think of it as a marketplace mixed with a social media platform, but it's free for agents. So you create a profile in RealTrade and you can get leads directly off your own listings. Imagine that. So we allow all the buyers, sellers to contact you directly. And of course, you can network with all the awesome service providers you need in real estate, like Jim, like lenders, like inspectors, like appraisers. They're on there that you can connect and help you facilitate business. And I want to definitely intro Jim. Jim's been an awesome resource here for myself on my own real estate business. Not only is he a real estate attorney, but he's an awesome founder of a great software called Title Leap, which makes, title closings more efficient. It's almost like a free contract coordinator. But of course, he owns his title shop, New Path Title, which I use for all my closings. It's one of the I've used a lot of title companies. I tell you, Jim and their team are one of the best. So Jim, why don't you give a quick intro here?
I appreciate that, Ryan. So there was a time when we had everybody in our shop was over 45 or 50. Now everybody in our shop is under 40 and almost everybody's under 35 and many of us are under 30. It's a whole new world. You can't be doing this stuff if you're thinking in antiquated ways. And I want to go over just a few things before we get started. My goal is to provide you guys content you won't hear anywhere else, right? I look over the outlines that are being served to you guys from the Florida Association of Realtors. My goal is to get you inside information that you won't be able to pick up from any other sources. There are no dumb questions. So anybody that has a question during the podcast, feel free to raise the question in the chat or raise your hand. There's every question that you have, there's going to be someone or many people in the room who've had the same pain. So don't hesitate to ask. We're going to try to keep this to 30 or 45 minutes. Turn on your cameras if you can. I'd love to see your reactions. It helps us move through this thing quicker. There's going to be a question and answer session at the end. We're going to give you some time-saving tools and show you how to be a more efficient agent. And you can text me in the future for any topics you want to see covered. Throw them in the chat for any topics you want to see covered. I've got the greatest part of my business is getting texts from you guys telling me the pain you've had in a transaction, because then I can turn that into a topic and we can talk about it and everybody can benefit from your pain. And so don't hesitate to contact me. I want to go over something that I think is vitally important that's getting overlooked. And I get these calls from agents and I say, there's ways to avoid this stuff. So I'm not going to belabor the point. Can you guys see the screen share on Title Advance, Ryan?
Yeah, I can see it crystal clear, Jim.
All right, so I sent out a title advance to an agent about 90 days ago. She did a closing. In her transaction, she offered her seller to use one of two title agencies. She used a title agency, not us, not a problem. I'm happy to be in the running. I'm happy to be on her radar. She's been doing this stuff forever. In the title advance I sent her, there was a note for a child support lien and a PACE, a Y Green mortgage, so a PACE loan. So she didn't read the title advance. It referred her to the other title agency and us, and they picked the other title agency, not a problem. And then on the day before closing, I got a call. And the call was, oh my God, a text. Oh my God, the seller's not going to close. They have to pay this child support lien. In reality, the child support lien was unwarranted, but it has to be paid even though it was homestead property. And so the reality is, had she read the title advance 90 days ago, they could have solved the problem. So what happened at the last minute? A couple of days before closing, they're having heartburn over the PACE loan. Nobody realized the PACE loan had to be paid. A couple of days, and then the day of closing, they're having heartburn over the child support lien. Order title advances. They'll save you heartache in the end. They're super easy to order. They're free to agents. If you don't know how to read it, not a big deal. Just text me. I'm looking at all the title advances that go out now, and I'm trying to send a little follow-up text if I see issues. But if you guys see issues, just text me and we can talk about it. Next thing I wanted to talk about is Seitzer Burnett. This is before we get into the good stuff. Seitzer Burnett just settled this is the commission lawsuits. Seitzer Burnett just settled with Keller Williams. Why is that important to us as agents? Because there are some provisions in the settlement that I think we can all learn from. I'll be happy that this outline will be on our website. The key takeaways from the Seitzer Burnett settlement that benefit all agents. This is what's getting incorporated into all the listing agreements for the agents that have settled. This language. The listing commission rates are negotiable and the amount you pay a cooperating agent is variable and optional. You just sneak it in there somewhere. It's the easiest thing to do. And if it ever becomes an issue, boom, you guys have that base covered. In
You know
my
what the irony,
opinion,
Jimmy, here is, like, we did a webinar on the Seitzer Burnett, which was a great turnout. Remember, we had almost
yeah,
100 agents in that one. You had mentioned this, putting this in the listing agreement when we did the presentation. It
no,
just,
and listen, I'm not a knowing-all, soothsayer or whatever, but the reality is there's a couple of key simple things that everybody can do to guard themselves against future liability. Are they suing individual agents? No, except for some massive agents. But brokerages that aren't doing this, or the brokerages that have settled are doing this. And the reality is these lawsuits started in 2019. Had this step been taken and had these things been taken seriously, it probably could have been avoided. I've given you guys, if you want to know more about this stuff, it's confusing, but I've given you a link at the bottom of the website, at the bottom of the outline. If you go to this link, there's a simple timeline and they talk about the evolution of the commission suits. And you can read just a couple of sentences about everything that's happened. Instantly, you'll be an expert. All right. Anybody have any questions about that stuff? I want to get into the good stuff now.
it's getting good. I will say this as an agent, right? This is the one thing that, your clients look up to you for, is your verbiage and your writing of the addendums. I mean, they're usually, when something comes up or an addendum is needed, it's important. It's going to have to be addressed. And, this is something as an agent, you can really showcase your professionalism. So definitely writing addendums is a big one. So excited to have an attorney that's helping us, show us out here to write addendums. Thanks, Jim.
You guys, we got we got buyers and sellers. They're looking for us to be experts, and we might not know all the answers all the time, but if we can spot the issues and you want to text me, we can figure out the answers, right? The good agent knows the issues. They don't know all the rules. They just know when there's an issue. That's all you need to do to be a great agent. If you know there's an issue, you know there's a place in the contract you can find it, we can write an addendum over it. Communicate powerfully. This is what we talked about last week. Part one was IRAC. I'm just going to go over it real briefly. What is IRAC? It's a way to write. You write about the issue. You write about the rule. One sentence about the rule. One sentence analysis. One sentence conclusion. You can narrow the issue with the other side very quickly if you communicate in IRAC format. That's 3 years of law school right there, condensed into 3 minutes, into 30 seconds. I just saved you guys 250 grand. Seriously, of all my takeaways in law school, and I got the book award for writing, issue, rule, analysis, conclusion. You write it in that way. You state the issue in one sentence. You state the rule that comes right out of the contract in one sentence. You blend the rule and the issue, and that's your analysis. And then your conclusion is your call to action. You always want to end with a call to action. Everybody forgets it, but when they finish reading what you've written, you want them to know exactly what the next move is. And I've given you an example in there. Part two, how to write the most effective addendums. Writing a good addendum, I've broken it down to an acronym. It's kind of long, but I think it works. PET duck. What does PET duck stand for? Price, event, trigger date, don't say too much, use defined terms, collateral dates don't change, and know your contract. Price, there must be a specific value. You got to come up with a value in there. I've seen too many addendums where people write a value to be agreed upon. I saw a pro agent the other day downtown. They got one of the awards for the top commissions for 2023, and they signed off on an addendum. I couldn't believe they signed off on. You just got to have an exact price in there. Event. There's got to be a defined event. We'll go over this in a little more detail, but you got to like really hone that event. What's it going to be? What's the trigger? What's going to happen? You need a date. You want to have a triggered date. You don't want to have some obscure thing when something happens. Put a date in there. It's difficult sometimes to figure out a date, but you got to have a date. Otherwise, it can be illusory and unenforceable. Don't say too much. We'll go into more detail about this, but keep it to the bare minimum to accomplish the goal. People want to write addendums that persuade people. Don't write persuasive information in your addendums. You just want to write the bare minimum to get to your goal. Use defined terms, capitalize words in the contract, closing date, effective date, personal property, closing, loan approval period, closing agent, escrow agent. These are all defined terms. Very important that your addendums use these defined terms. Collateral dates don't change. If you change the inspection period and want to extend the loan approval period, say it. Otherwise, it does not change. So the collateral dates, if you have a contract, and I see this all the time, if you have a contract and you're extending the inspection period, the agents think that the loan approval period extends. It doesn't. The loan approval period stays the same. If you want the loan approval period to extend, you have to say it. The other thing I'll pause to mention is, you guys, take a look at your contracts and make sure the dates work. What do I mean by that? I saw a contract the other day, the loan approval period extended past the closing date. That just creates unnecessary dialogue. The reality was, on the day of closing, the agent hadn't done a great job of explaining to them the significance of the loan approval period. And so there's this whole dialogue about the buyer not getting their loan and all this unneeded discussion back and forth. And so they're fighting, and the loan didn't close. And the reality is, had everybody been a little more clear and thought about the dates ahead of time, you would have a whole lot of not dialogue. And so take a minute. If you're writing it, look at it. If you're receiving it, look at it even a little harder and make sure you don't have conflicting dates. And loan approval periods that extend past the closing, it seems like a no-brainer. No one would ever do it. Trust me, we see it once every 2 weeks in here. Know your contract. What are you gonna say, Ryan?
No, I said it's a good point. I've seen it myself. Don't have the, the
Yeah,
loan.
that's like, I hate to make anybody feel bad, but that's a rookie mistake we can all avoid. Know your contract. Contract is good. It's been so well thought out. I was looking at a contract the other day from New York. New York's contract, I hear realtors complain all the time about Florida's contract form. If you saw the New York contract form, you would thank your lucky stars we're doing business on the far bar. It is the worst written transactional document I've seen in a long time. A whole bunch of party of the first part and party of the second part, and you lose track of who's the party of the first part and the second part. Our form is so well written, and it's so understandable, and it's so easy to digest if you take the time to read it a couple times. The most important thing you can take away from this meeting is know what the contract says, and don't write something in an addendum that conflicts with something that's already well thought out in the contract. If you know what the contract says and you know what the parts of the contract apply to, when you write your addendums, it's going to be so much easier. And I'll give you an example. And hopefully the person who wrote this isn't on the podcast today. So there's an actual addendum. It said, and this addendum ended up opening up a whole lot of liability to the seller's agent. It was really terrible. So I found this in an actual addendum. Seller will pay, this was at the buyer's, it opened up a whole bunch of expense for the seller, and the seller's agent didn't pick up on it. So we had the seller sign it. Not that it's the seller's agent's responsibility to sign it or not, but the seller's agent that could have said to the buyer's agent, hey, this is a reword of existing terms in the contract. Let's narrow this thing up. before the seller ever saw it would have saved the seller a whole lot of money. And then ultimately, the seller's agent had to go out of pocket with their commissions because the seller was complaining so bad. What's up, Jorge?
Yes, actually, I wrote one of those addendum myself in one transaction because they told me that they need to be specified on the condition at the end of the contract when you add everything. Just to add it, even though it's inside the contract, just to make it, emphasis on it that they have to close all the permits. So I shouldn't avoid adding that into the specific into the contract.
Well,
Right.
there's a couple of issues that you're talking about. So when you talk about permits, you got to be careful when you draft an addendum that you don't narrow the terms of the contract. In other words, the contract is written broadly so that it captures a whole lot of issues. And so I'm going to give you an example right now that'll maybe help clarify the question you have. But but having said that, there's some great language that you can add to contracts if you are representing buyers or if you are representing sellers, and we'll go over that in a minute. So in this particular example, the seller says the buyer's agent writes into the contract, seller will pay close all open expired permits, special assessments, and the property shall be free and clear of all taxes, liens, and assessments. What's contemplated here? 9F assessments or condominium assessments? How do you convey property free and clear of all taxes? It's already in the contract in line 472, and liens are already dealt with in line 412. It's all prorated. Liens are already talked about. So what ends up happening now is you have this huge discussion about what did the parties mean. The closing agent has no clue. It says they're going to pay all the taxes. Now that means they're going to pay all the taxes when typically taxes are prorated. Are we talking about special assessments as they relate to condominiums and the condominium rider? Or are we talking about special assessments as contemplated under the municipal assessment section of the contract? What's up, Jorge?
No, about the assessment, that was another concern that I had. There's some apartments that the seller knows that they're gonna put a new assessment into the property. They've been in discussion with
Before we even talk about assessments, we gotta figure out what kind of assessments we're even talking about. Are we talking about condominium assessments? Or are we talking about special assessments as contemplated in the main contract as imposed by municipalities? Another mistake I see frequently is sellers and buyers agents don't know the difference between these two types of assessments. And it says right here, if you read the contract, and I don't want to make anybody feel bad, but it says these are
As public body to not include condominium homeowners association.
I've had many discussions with with agents that did not know that this did not apply to condominium associations and homeowners associations. These are assessments that would be imposed by municipalities. Delray is a good example. Delray has a section of the city that has water main improvements. And so when they did the water main improvements, they specially assessed the houses that were benefiting from the water main improvements. It wasn't a general bond. It was just local to a dozen or so streets. Those are the special assessments contemplated by that section of the contract. Don't go into your addendums and say stuff like this, special assessments, because nobody even knows what you're talking about. What's up, Wendy?
If we do your title search ahead of time, will you be able to see those special assessments?
Yep. So the title advances that we send out will have these special assessments. That's a really good question. So there's two types of information that we reveal. There's information that's in the public record, and then there's information that's in the municipal records. Municipal records are things like utilities and special assessments that might be owed in special bonded areas with water improvements and things like that. But if those issues are then memorialized in the public record, then they'll show up in the title advance. So the municipal records have things like open permits, code violations, utilities, and utilities fines, and those kinds of things. But once a judge rules on those issues and they become liens or things like that, then they go into the public record and they'll show up in a title advance. Not all municipalities give you that information, but the ones that do, we scrape it and Ray puts it in the title advance. So he has a section that's about the public record where you're going to always see the mortgages and the judgments and the things that are recorded in the public record, like your deed is recorded in the public record. But then if it's available to us, we're also going to scrape the municipal records and give you those things. When you close a title transaction, when you close any transaction, the title agent also orders what's called a municipal lien search. And we have companies that we do them through, like PropLogix and things like that. I do a much more in-depth search, but we do the best we can and to provide it free of charge so that you guys get something quick and dirty. And if the municipality makes those records available, we'll make them available to you.
But it is, just go back to the contract there. This is gold. I've actually had this come up on my clients. They think it's special assessments from the condo. So just highlight that for them. No, this is for public works projects. And I give them an example of the only time I've ever seen it come up in my 20+ year career was Port St. Lucie. They had the same thing. There was a water municipal hookup that was spread out over a lot of years, right? And the new buyer inherited those, payments because they'll be actually using that, not the seller, right? So that's how it was, worked out.
And how would you know, like, the difference? It goes back to that rule we talked about at the beginning. Read the contract several times. It's spelled out there. I did a lecture for a bunch of agents the other day. The broker had 20 years experience, and he said to me, he got burned on one of these things recently. It's an easy mistake to make. What's up, Chris? I think you're not muted up. Let's see, asked to unmute.
You got me now? Sorry
Yep.
about that. So a CDD, would that fall under the public body as well?
A community development district?
Correct. Or is that
Yeah.
a separate issue?
No, that if the CDD had a fee imposed by virtue of the CDD. I'm trying to think of an example. I think I saw one of what you're talking about up in Vero Beach many years ago.
So you're seeing them a lot in Port St. Lucie. Newer communities have CDDs.
Mm-hmm.
And I know that, like, personally, I disclose it with an addendum. It's built into the tax bill. So it is in the tax bill already.
Mm-hmm.
I just wasn't sure if it fell under that particular paragraph or it would be a separate paragraph.
No, that would be the paragraph where it'd be captured.
Yep.
Okay.
Pull that up again, Jim, just so people can see it, because believe me, there's a lot of confusion over that part of the contract.
Let's see.
Right there.
Alta-Star.
Alta-Star right there. There it is.
So this section right here talks about special assessments of any nature except for homeowners association and condominium. So Chris, I've been doing this for 40 years and that's the first time anybody ever asked me that question. But I would tell you, fighting from my toes, not from my heels, that would capture CDD if the CDD had fees. Now I've seen lots of CDDs that didn't have fees, but if the CDD had fees associated with it, that would be captured in that paragraph. And everybody knows what we talked about it real briefly a second ago. When Chris mentioned the CDDs showing up on the tax bill, PACE loans and Y-Green loans. I don't want to beat a dead horse to death, but further to death, but PACE loans and Y-Green loans, these are improvement loans that people get for windows, roofs, anything that makes the house safer. I saw an interesting term the other day, hardened, right? Anything that makes the house hardened from a Florida hurricane perspective, it makes your house hardened. Thought that was an interesting term. So you see an old house with brand new windows and an older couple. I hate the stereotype, but an important question for you during the listing appointment would be, do you have a Y-Green loan or a PACE loan? Your title advance will reveal this. Why is this a problem? Because when you go to closing, the seller expects, because they were told by the loan officer that this loan can be assumed by the buyer, but no buyer wants to assume that loan. And there's a new disclosure in the contract forms about this now, pay-through loan and Y-green loan, but if nobody knows what they are and nobody drafts the addendum, then nobody ever uses it, the rider. So know what those things are. You know, I had an interest, the woman that had the child support lien, she told me the other day, she says, that's something that title does. I don't need to worry about that. Those weren't her exact words, but in the old days, title was a black box, right? But we all know today with MV Realty loans and things like that, all these little things that you can do that we're trying to make easy for you to do are going to make it easier to be an agent. So I think saying that's, you know, like that's something that title does, I don't need to be aware. You know, I hear you, and that's something that we're going to do. But if you can head that stuff off at the pass before the contract ever gets to title, that's gold right there for you guys. All right, so without beating this thing up too badly, we can all identify the problems with this addendum. Again, price, event, trigger date, don't say too much, use defined terms, collateral dates don't change, and know your contract. Tips: don't tell a long factual story. Tell the bare minimum to achieve your goal. The price, the purchase price is, right? That's all you need to say. You don't need to say why you got to that purchase price. You don't need to say that the pain and the discomfort everybody had. Never tell the facts leading up to the need for the
I will
addendum.
just say too, never, you know, if you do a price reduction, don't put in there that it's for repairs. You know what I mean? Because the buyer's, you know, lender, I've seen this happen on a buyer's agent, you know, the lender kicked it back. Well, what repairs? And then we went to a whole can of worms on what the repairs were. And the lenders, you know, in their underwriting is, you know, looking into it. So, yeah.
Almost everything can be reduced to one sentence. If your addendum is more than one sentence, there are exceptions, absolutely. But if your addendum is more than one sentence, you're probably writing too much. I've sat in depositions where realtors were sweating when the lawyer said, well, what did you mean by this? They wrote a story. I'd read one, and they wrote a story about how the property had all these problems, and the seller's agent signed off on it, and then it was the history of the property, and the seller signed off on it, and then when they went to deposition, you know, it was easy pickings for the attorney to say, you know, well, you agreed to this in the addendum. Why are you telling us the facts are different now? Tell the bare minimum. Use defined terms and dates. Don't reinvent the wheel in the addendums. Always use the defined terms and dates in the contract. So it's easy to identify the defined terms, right? In the contract, throughout the contract, you're going to see all kinds of terms that are in parentheses and quotes, and they have capital letters. So the easy ones are going to be like escrow agent here on line 29. Can you see my cursor, Ryan?
Yep.
And then you've got loan amount, and then you've got closing date, and then you've got ones that everybody screws up in the financing provision. It's a very specific thing. It's called the loan approval period, you know, and that's capital A, capital E, capital P. So there's a loan approval period right here, 102. Where is it defined? Oh, here it is. On line 89, it's defined, loan approval period. Use those exact terms. Use the capitalized letters in your addendum. Now nobody has any mistakes about what you're talking about. And when you're talking about a closing, sometimes you're talking about seller's other property or buyer's other property. When you're talking about your closing on the subject property in your contract, that would be capital C, capital D. When you're talking about the closing of a collateral property, that's going to be a lowercase c. There's your uppercase C. Oh, I'm going to show you guys something that's screwy in the far bar that's little known fact. So here you see in the contract, they're going to use a term called closing agent. Every time you see the word escrow agent after you see it the first time, it's not going to be defined. But when you use the term closing agent, there's a difference between the closing agent and the escrow agent. And not a whole lot of agents know the difference. The closing agent is defined way down in the contract after it's first used. So just a little different application in the contract, you're always going to see the terms defined. There's financing right there. Every time you see the word financing after it's defined, it's just going to say financing with a capital F. Closing agent, for some reason, is defined as later in the contract, but used frequently until you get there. So you have the escrow agent. All the escrow agent does is hold the escrow. Then you have a closing agent, and the closing agent is the one that actually performs the closing. And I would encourage all you guys, this is a slight diversion, but if you are letting third parties hold your escrows, don't. Unless you can come up with a compelling reason that you don't trust the title agent or something, the laws are so good, the contract is so good, don't park your money with third-party escrows anymore. Send your money right to the closing agent. If you don't, you could have, you could be victim of cyber fraud. It is more rampant than ever. It's 40, last I looked, it was $40 million a month. No. Yeah, $40 million a month just on title agency pirated transactions alone, 40 million a month. And I know personal stories about that, of people that have been victims. So don't park your money at a neutral title company. Take your money and make that initial movement right to the closing agent. So this provision here in the contract would have the name of the actual, not just the escrow agent, but they would even be the closing agent. And all you got to do, if you're the buyer's agent, you don't know who the closing agent is, take 2 seconds, contact the seller's agent and say, who's the closing agent going to be in Palm Beach County? The seller chooses. And if you want to control title and you're the buyer's agent, you can always write in paragraph 20, the closing agent shall be New Path Title. Just a self-serving plug there. All right. Defined terms, we talked about that. Four corners rule. Here's something that a lot of agents don't know. A lot of, I hate to say it, attorneys, well, no. It's an often overlooked mistake by a lot of people. When you hold up, the contract, that contract should tell the whole story. It's called the four corners rule. Anybody picking up that document should be able to understand the whole transaction just from looking at that document. If you have to look at emails, we talked about keeping it brief. You haven't told enough, but that contract is the whole story of the transaction. So if it ever has to go to court, or it ever has to be interpreted by an arbitrator, or never has to be interpreted by anybody, everything has to exist in that contract. Well, I hear all the time from agents, and I'll give you a perfect example. Well, everybody knew, but those aren't the third parties. Everybody who reads the contract has to know without that other backstory. So in the contract, there's kind of a confusing provision that, again, often gets overlooked. And it's the effective date. How simple is this? The effective date. Can you see line 49, Ryan?
Yep.
The effective date is defined by 2 events, not 1. Everybody says the same thing. It's the last person to sign. And I would agree with you. 99 times out of 100, the last person to sign is the correct statement. However, the contract defines the effective date as the effective date as the last person to sign and delivery occurs. So we had a transaction up in Port St. Lucie, older woman, expensive property out in the country, and the realtor had to drive back and forth from North Palm to her office to get stuff signed, and then she had to bring it back, and she had to send it around, and there was a delay sometimes, and the woman would only meet at night. So the contract was signed Tuesday, but it wasn't communicated until a little while later. Sometimes she had to drop the stuff off, and her the daughter of the mother review it with the mother, and then she had to run back up there and pick it up. So the contract might have been, the addendum might have been, or the contract might have been dated Monday, but by the time it was communicated, it was Wednesday. So what's the effective date? If she was the last one to sign, it's Wednesday. I'm seeing a bunch of faces that I'm glad you guys are running your cameras. So it says right
So
here.
just to be clear on this, it's delivered, right? So let's say
Here's what it says
buyer's agent.
exactly. The effective date of this contract shall be the date when the last of the buyer and the seller has signed or initialed and delivered.
Yep.
So what
So basically, yeah, if the say your buyer's agent, you send it, the expiration is Tuesday and the seller signs it on Tuesday, but the listing agent doesn't send it back to you till Wednesday, that it's executed, signed on Tuesday, the effective date is Wednesday.
Yeah, so within that particular transaction, it became a real issue. It was a big expensive horse farm. The inspection period was running out. The buyer was arguing for one inspection date expiration, and the seller was arguing for another inspection date expiration. We were the title agent. We advertise these dates in Tidily, but we can only advertise the dates that we see based on what we talked about earlier, the four corners rule. So we're looking at the contract, and it had a Monday effective date. The mother signed on Monday, but the daughter came over Tuesday and reviewed it with the mother, and the agent didn't pick up the document and communicate it until Wednesday. So Wednesday was the effective date.
Yep.
And so a simple addendum that says 4 or 5 words, the effective date is Wednesday, with the actual date, clears everything up, and it can be electronically signed and circulated and sent to the title company. Now everybody's on the same page. But without that one little stutter step, there was incredible heartburn by the agents because of the way the contract is drafted and the gap in everybody's knowledge and perception and all the little things that go into making confusion. So addendums are powerful tools. They can be used for everything. What's up, Robert?
I was wondering, would you have to communicate through email to have a record to the other agent? This is just to let you know that, today is Wednesday. I've got the seller signed today, and today will be the effective date. So do you need that? Would that be a good idea to have that proof in email? And then you'd make the call to the closing agent to say, just to let you know.
Perfect example of what we talked about. First of all, I want to say something that under the new contract, is texting a form of notice communication in the new contract? Yes or no? No. Texting is no longer recognized as notice. The old contract said digital communication all qualifies. Under the new contract, texting no longer qualifies. But then the other important point that Robert brings up is exactly what we talked about earlier, the four corners rule. Are the emails contained within the four corners of the contract? Nope, that would come in under what's called parole evidence. So if you had their litigation or something, then you could bring that stuff in. But nobody wants to litigate these things. So you take your contract and you just put a 1-sentence addendum together that says the effective date is blah, circulate it digitally, and then you're done. Because those emails are great, but sending them to the title agent, now the title agent has to interpret it. Title agent's job isn't to interpret, it's to execute. We have no discretion. We can make no opinions. And that brings up another point that I want to bring up in a minute. We're getting up on 37 minutes. Use addendums for everything. We talked about the four corners rule. Use addendums for everything. Cover your exposure. Parties can digitally sign and send to your title company right away. Title companies don't know what you don't tell us. So I've learned from experience the hard way, everybody on one camp is in agreement on a date, but everybody in the other camp is unaware and the title agent's unaware. So we're broadcasting what's in Title Leap. We broadcast the critical dates. So we're broadcasting the critical dates we're aware of. And now the seller side is all upset because they knew about something that no one else was aware of. Post-closing addendums. First and foremost, don't do it. If you can come up with an amount, Tajay, one of our closers here, taught me a valuable lesson the other day that I had long forgotten. Don't put anything off. If you can resolve it all at the closing table, resolve it at the closing table. Figure out an amount. Get your buyer and your seller over that hurdle. When you do post-closing addendums for leaks and things like that, that just creates a world of problem for other issues. But if you do have to do it, if you do have that roof that's still leaking, follow the pet duct closely, come up with exact triggers, and we can talk about it more. But here's a really important fact. Most post-closing issues can be solved by the seller's mandatory escrow clause in the contract. And a lot of agents don't realize that tool exists. If you guys walk through the property and you see something that didn't occur, that wasn't in existence, that's missing, that wasn't there on the effective date, right? That sink is leaking on the walkthrough. That's something that's covered by post-closing, the as-is property maintenance requirement and the seller's mandatory escrows. We talked about it last week. That stuff shouldn't be held over. It should just be escrowed for, and the thing should be closed. We can talk about that later. We can talk about that on another show because that's a whole long rabbit hole. But there's a mandatory seller's escrow provision. If you got to do an escrow, it's captured in the contract. Don't make up your own addendums over it. It's already in the contract. And if it's a contentious transaction and you're drafting an addendum, throw this sentence in at the end. If the transaction is contentious and my addendums are right, to date, no party is in default. Now you've put something in paper, you've snuck it in, and they can't later say, oh, well, you were already in default. No, if they sign off on it, the day that addendum was written, no party's in default. I can't tell you how many times that's helped us. Tidbits, things to think about. Who knows the mandatory seller escrow, how mandatory seller escrow works? We're at 40 minutes. I talked about that a little bit. I'll just mention it briefly. Mandatory sellers escrows. There is a provision in the contract that says if the property is not maintained in the as-is maintenance property requirement on line 257, it says that the seller has to escrow over those issues. Use that provision. Don't use these holdover clauses in the contract. Don't use holdover clauses in addendums. Like you're going to do this work after the closing and the money's going to go this certain way. Use that to your advantage. We talked about this. Did you know there's a difference between an escrow agent and a closing agent? And last but not least, what are the only two ways that escrow can be broken? And this is really important because it can always be defeated. But what are the only two conditions that allow a title agent to release money? I don't care how obvious the facts are. What are the only two conditions that allow the escrow agent to release money?
Everybody agrees?
That's the first.
Yeah.
Everybody agrees. It's got to be in writing, but everybody agrees. A phone call doesn't work. And what's the second condition? The only time, I don't care how obvious the facts are, the only time the escrow can be broken is if a judge orders. The parties have to agree or a judge has to order. I'll give you a perfect example. If you guys have heard this before, don't tune out. Everybody forgets it. There was an inspection of a very expensive property. During the inspection period, the buyer gave clear notice. It was a horse property, very expensive driveway. Where is it? Right to cancel. Very expensive driveway, horse property. The buyer did their inspections, had long inspection. There was a long inspection period. And during the course of the inspections, buyer found another property and they thought they were going to be cute, cool, whatever you want to call it. They were going to cancel the contract, take their big fat deposit. It was 300 grand on a 3 million purchase. Maybe it was more, 500 grand. It was a lot. I think I want to even say it was like 750 grand. It was a disproportionate deposit. So the buyer cancels and they're fully expecting that they're going to get their money back like that. And they're going to go put their money down on another piece of property. The buyer cancels, all plain as anybody could say, any title agent should release the money, right? Wrong. Why? Why could the title agent not release, even though it seems obvious and intuitive that the title agent should have released? Because of this sentence right here. Anybody want to take a stab at this? Why didn't the title company release when the buyer during the inspection period said, we're canceling, we want our money back, here's where you send our money? All right. Right here, line 267. However, buyer shall be responsible for prompt payment of such inspections for repair of damage to any restoration of property resulting from some inspections, and for repair damage to the restoration of property resulting from such inspections, and shall provide seller with paid receipts for all work done and shall survive the contract. So in this particular transaction, the buyer had a septic system. Buyer called a septic inspection company and the septic system inspection company drove a huge pump out truck onto the job. Instead of just driving a little pickup truck, they drove this huge pump out truck. They were just coming to inspect the system. They were coming back from another job, and the driveway was 1/10 of a mile long, paved, and the last sections were all tiled. When they drove the pump out truck, it loosened up all the tile. They went around the circle drive, and the seller claimed they did $150,000 worth of damage. And turns out it was dramatic damage, but the seller was in Europe and they couldn't get home to get estimates together. So they said, we're not releasing your deposit. And the buyer was like, what are you kidding me? This is obvious. We're canceling. The contract says it. But if there's a dispute, the title agent can. And there was a dispute over the repairs to the property. So we weren't title agent on that one. We represented the seller in that one. We weren't the title agent, but we couldn't, bottom line is the money couldn't have been dispersed because there was a dispute over repairs. So 2 times the title agent, 2 things have to be, the only 2 times the title agent can disperse money, the parties agree or a judge orders. And even if the facts are as obvious as they could be, sometimes we can't release the money, even if everybody would agree, oh my God, this is so obvious. You guys, I can't believe you're holding up my transaction. All right.
Let me just add this real quick on this one, Jim. I had this in my career. I had this happen one time where the inspector, I was representing the buyer, went on the roof, and the seller, listing agent, was saying that the inspector cracked roof tiles.
Yeah.
And the deal was canceling. They wouldn't release escrow, for the cracked roof tiles, and it ended up being a bit of a mess. The only thing is, I did look in the garage, and there was extra roof tiles in the garage. So I said, hey, you got extra roof tiles in the garage here, you can replace them. They ended up holding a little bit of the deposit. I think we released everything except like $500.
So the whole goal is everybody knows the rules. I love the anecdotes that people have, and I'm sure you guys have all. Don't hesitate to chime in with anything that you guys have encountered that sounds like this. But we saw one the other day. It was mold inspectors now have really clever cameras. And so the mold inspector came into the property. The seller knew they didn't do the right job. And so the mold inspector came in and he started unscrewing face plates to the switches and outlets. And they have a little fiber optic camera. The seller, the buyer's actually allowed to do some level of testing, and some of the testing, could fall into the category of destructive testing, right? So if you're cutting little holes in the wall to stick cameras in and look around, and you can put some caulk over them and call it a day and it looks perfect, that's one thing. The seller was being obstinate, absolutely not. And so they pulled the the faces of the outlets and the light switches off, and they took the fiber optic camera and they stuck it in between the little tiny gap in between the outlet and the sheetrock. And they looked at the inside of the wall and they said, this thing's covered with mold. And the seller, started screaming, oh, you destroyed my property. And you put the outlet back on and you can't see a thing. And it just turned into a giant mess. And it's really important that we understand how the contract works, but they had no right in that transaction to hold up the return of escrows because the buyer had canceled and there was no damage to the property. A light switch outlet switch can be screwed on and screwed off. And so there's great provisions in the contract, and we just have to figure out how they work with practical applications that we see in everyday life, and then we can figure out what the answers are. All right, we are at 48 minutes. Went longer than I thought. I apologize. I hope you guys got something out of this. We got a couple of chats in here, Ryan. Did you see those?
Yeah, Wendy had a question. She's got her hand raised.
Yep. What's up, Wendy?
You're on mute. You're on muted.
I wanted your opinion about whether or not agents shouldn't attend inspections, because I've heard some agents say no, but in this case, when you're talking about excessive damage to the property, I always go, whether I'm the buyer's agent or the seller's agent. So I just wanted your opinion on whether we should be attending inspections or not.
I've never heard a good reason why a broker would say, and I'm totally open to hear it, why a broker would say don't attend. I always like the concept, and Pablo taught me this a long time ago. agents have to sell the house several times. They have to sell the house at the showing, and they have to sell the house at the inspections, and they have to sell the house at the appraisal. And, you know, I don't see any reason not to be there for an inspection. But if somebody has hard feelings otherwise, I'm totally open. The only reason that I could see that somebody would say, a broker might say, don't attend an inspection, is if the inspector says something or reveals something that doesn't make it into the report, then the argument of the other side could be, well, you know, Wendy was there and she heard the inspector say it. We don't, you know, it just opens up dialogue. But in general, I don't see a reason why you wouldn't attend inspections, because you're going to learn. You're going to learn stuff about the property in the process, and I think that's valuable. The whole thing is knowledge is key, right? But I could see a situation where an inspector might be sloppy and not write everything. That's the first instance that comes to mind. I'm sure there are others, but I think the value of being at the inspection outweighs not being at the inspection. Now, what I will say about inspections is I have seen when real estate was frenzied and people were closing left and right, and buyers were making more impulsive purchases than they are today. I have seen a lot of buyers say to agents, hey, will you do the walkthrough for me? That's something I would definitely avoid doing. And if you tell the buyer, hey, let's have the inspector do the walkthrough, that's a great time for having the inspector do the walkthrough and them take the hit, because, you know, what's our job as agents? We're here to find buyers and sellers and guide our clients and match them up. Not necessarily know everything about the physical elements of the property. So if a buyer asks you, hey, will you do my walkthrough for me? I would politely say, can we get the inspector to do it? I'm pretty sure for $100 we get them to come back and do that for us, because they're more intimately knowledgeable about the details of the property. Boom, now you've walked away from that whole potential quagmire of liability. We did so many agent walkthrough disputes recently, you know, when things were a lot more frenzied. So I hope that answered your question. Anybody else have anything? Ryan, you want to go into your massive value proposition bombs over issues of RealTrade? Oh, Pablo's got a question. Go ahead, Pablo.
No question. I just want to wait a little bit on the title advance to my fellow realtors. Honestly, it's a fantastic tool. I remember what Jim was talking about in the very beginning when you started doing it. And I went to this listing appointment, and I kind of know this lady. The property, I think, was worth like $400,000 or so, and she have a mortgage of $60,000 or $80,000, very little mortgage. And Jim told me, Pablo, use the title advance. I was like, there's no need to use the title advance, Jim. She only have, I saw the mortgage statement. She only owned $80,000. And he told me, Pablo, just title advance. So I didn't listen, Jim, and I should have. Went on the contract. We started to do the, obviously we use, new pad title. They started to do the search in the property. And then she has this violation on the property that she shouldn't have for like 5 years ago. And it was accruing every day, like it was like $50 a day.
Pablo, do you remember what the violation was for? It was for the most ridiculous thing you ever heard of in your life. Anybody on this podcast that's heard of this, I give you high applause for. Go ahead and tell them what the violation was for.
$360,000. I almost didn't close the property. She didn't have money to pay commissions or even close, and we were already on the contract. But anywho, so James went to court and fight it, and we get, I don't know, $5,000 or something like that, you know. And I was able to close. So it's something I can share with my fellow realtors that had the opportunity. Use that title advance, like always, like 100%, because it's going to save you a lot of time with addendums and a lot of headaches in order to close. And you're going to look great with your clients. I just want to share my experience.
You guys, Pablo, that was not a paid endorsement. I hugely appreciate that.
No, that was reality. 100%. Every time, I believe the realtor, we are stronger, not when we compete with each other, but when we help each other. You know, it's enough business for everybody. And if I have opportunity to save money and time on one of my fellow realtors, I'm always going to do it, you know, and this is one of the many stuff that happens.
Hours of time just typing this addendums.
Pablo's code violation. Everybody should listen to
my
this.
client.
Everybody should listen to this. Pablo's code violation, his client's code violation was non-contrasting address numbers. The house was pink. The address numbers on the house were pink, and the people were getting fined $50 a day for years and years and years because their address numbers did not contrast with their house. Who goes to closing and thinks you're going to have a violation of that magnitude over something so foolish? You know, it's just the way it happens. But that seller, yeah, it's just the way it happens. So I appreciate the endorsement, Bob.
No, it's just the truth.
Awesome.
Money and time to people.
I agree. Title advance is a good one. So definitely I use it on all my properties, definitely with listings coming up too. So I'm an informed agent going into the listing, what the issues are with the house before I even go in there. So anyway, this has been a really good one. This has been a great webinar, Jim. Great job on this. And you know, your expertise here, especially from an attorney point of view with addendums, has been invaluable. But you know, we do this bi-weekly. We're glad you guys could attend. Jim's favorite word is iron sharpens iron. As you can see, we're all learning from each other. If you haven't checked out yet, I put links here with the website to RealTrade. RealTrade's an online marketplace and social media platform for real estate agents. We're the home of the double dip, as Jim likes to say. Literally free leads, guys. I'm trying to get you free leads on RealTrade. And of course, you can network with the awesome service providers like Jim, and there's inspectors, appraisers, everybody else that you need. We're going to be working hard on getting some handyman on there, some handyman. We have one, but we want to get more because every agent needs that too. But definitely check
Anybody
out
needs a
RealTrade.
handyman, yeah.
No, we're gonna get. I want about 4 or 5 good ones because that's one a lot of agents ask for. We all need them, so we're gonna get them on RealTrade. But too, a big shout out to Jim. You know, I love using Title Advance. We just spoke about that. That's a great feature. Also, which is really awesome, is the closing software that Jim's developed, Title Leap. It's like a free contract coordinator, guys. I use it. Keeps track of all your drop dead dates. You get texts, you get emails. Everybody's in one communication. Love that. Check out Title Leap when you use New Path Title. Of course, don't forget your Title Advance. Just do it on every single deal, so there's no surprises. Can save you hours of time. It's actually would have saved me thousands of dollars on a stupid MV Realty lien that I would have known it going into a real estate closing would have saved me literally $2,500 doing it. So
15,000 MV Realty liens in Florida. 15,000 MV Realty liens in Florida. You're going to see it sometime during your profession for sure, and it'll ruin the closing.
What's the website for RealTrade?
It's put it in the chat. It's www.realtrade.io. You can just Google RealTrade. It'll show up. We have some good SEO there, so you can just Google RealTrade. But yeah, check that out. Love to have you guys on there. Get connected with Jim on there and myself. We're always posting great things. Use a lot of good info shared on RealTrade for us agents. And you can promote your listings, which is awesome, for free. We have over 2,000 agents now on RealTrade using it. So, you know, check it out. You can do
Am I
live.
still stuck on the screen share, Ryan?
What's that?
Am I still stuck on the read
Yeah,
screen
you're still on screen share, which is an important part. The cancellation that should be burned into our memories now about the, you know, the damage from the inspector.
Yep.
Yep.
Absolutely. Realtrade.io.
Yep.
All right, you guys. Title Leap, Title Advance, text me 24/7. Happy to help you out, even if I'm not the title agent. Happy to help you through any transactional pain you're having. Huge value bombs. Hopefully you guys got today. I know I got a ton from you guys. I love your questions, so text me and let me know what we can talk about in the future. I've got a whole catalog of stuff to talk about if you guys don't have anything. All right. Be good.
Thank you.
You bet.
Thanks, Jim. Appreciate it. Bye, guys.